If you've been appointed as a trustee, conservator, or administrator, and there's real property in the estate, you're not just managing assets, you're managing expectations, liability, and sometimes difficult living situations. And in some cases, where real estate is to be maintained for income purposes or long-term legal disputes that are hindering a property's final distribution, you're going to be managing real estate for the medium and long term. In this video, I'll walk you through the top property management questions fiduciaries should ask and what you can do to protect yourself while preserving the value of the property and the trust of all parties involved. If we haven't met, hi, I'm Andrew DeVries. I help professional and family fiduciaries sell probate and trust real estate in the San Francisco Bay Area with less stress, less liability, and for more money. I've closed over 900 of these transactions, and with this channel, I'm here to help you avoid costly mistakes. This is one of the most common and riskiest questions fiduciaries ask as it relates to property management. Can I just rent the property out and get it productive for the trust while we figure things out? And the answer is, it depends. Whether you're a trustee, an executor, or a court-appointed fiduciary, your authority to lease or manage real property depends entirely on the legal documents that created your role. If you're a trustee, start by reviewing the trust document. Some trusts grant explicit authority to lease or manage property, while others do not. If it's silent or vague on that matter, you may need legal guidance before proceeding. If you're operating under a probate, you'll need to check your letters of administration. Do they authorize you to manage the real property, or are they limited authority only? In many California probate cases, renting out a property without prior court approval can create legal liability, even if you're acting in good faith. And here's the risk. If you lease the property without proper authority, you could expose the estate or yourself to legal action. This might include disputes from heirs, breach of fiduciary duty claims, or problems later when trying to sell the property with a tenant in place. Our advice? Always verify your legal authority first before signing anything. That means working with your estate attorney to confirm your powers, reviewing court orders if probate is involved, and making sure your actions are defensible if challenged. We work with legal counsel regularly to help fiduciaries clarify this up front so you can make smart decisions without second guessing later. Question number 2. Someone's living in the house but they're not paying rent and they won't leave. What do I do? Sometimes it's a surviving sibling, sometimes it's an adult child, an ex-spouse, or a tenant with an expired lease. In some cases, it's even a squatter or an unauthorized occupant who moved in after the decedent passed. And as the fiduciary, you are now responsible for the property, even if you didn't place that person there. Here are the key risks. There may be no lease or written agreement. You're likely not receiving rent, which creates a holding cost issue for the estate. Occupants may damage the property or block access. You could face delays in the sale, legal complications, or even personal liability if something goes wrong during the occupancy. So what can you do? Option 1 to consider might be cash for keys. In many cases, we can help you offer a dignified exit strategy for the tenant or occupant. A small cash incentive to help the occupant move out voluntarily. It's faster and more cost-effective than eviction and can be handled discreetly if approached properly and legally. Option number 2 to consider might be a legal eviction. If the occupant refuses to leave and they're not protected under a valid lease or court order, we'll help coordinate with your attorney to begin the unlawful detainer process. Timing and strategy do matter here, especially in the Bay Area where tenant protections can vary city by city. Whatever path you choose, you should never go it alone. We work closely with your estate attorney and property litigation counsel to make sure that A, your authority is valid, B, your communication is documented, and C, the next step is legally sound. Bottom line, you are not powerless, but you do need to act carefully. We're here to help you take control of the situation without escalating conflict or exposing the estate to unnecessary risk. Another important question that comes up quickly in any trust or probate situation is, who's responsible for taking care of the property while it's still in the estate or trust? The answer is you are, at least until it's sold, distributed, or transferred. As the fiduciary, you have a legal obligation to preserve the value of the property for the benefit of the estate and its beneficiaries. That doesn't mean you have to fully renovate, but it does mean you need to protect it from damage, deterioration, and liability. Here's what that usually includes. Number 1, basic maintenance. Regular landscaping to avoid city citations and maintain curb appeal. Trash removal and clean out, especially if the property is vacant. Preventable pest control in regions where infestations are common. Number 2, safety and liability. Addressing any clear safety hazards like broken steps, unsecured windows, or exposed wiring. Maintaining homeowners insurance or switching to a vacant property policy if no one's living there. Ensuring smoke detectors, locks, and utilities are functioning until the property is sold or transferred. Number 3, documentation and transparency. Keep receipts and service logs. This shows the court and heirs that you acted responsibly. If you're paying for maintenance out of pocket before the estate has cash, document your reimbursement rights clearly with the attorney. The key takeaway is this: you don't need to upgrade the kitchen, but you do need to make sure the roof doesn't leak. We help our fiduciary clients strike that balance by protecting the estate without over-investing in things that won't deliver a return. And that's not just best practice, it's legal self-defense. Your job, whether as a trustee or court-appointed fiduciary, is to preserve and protect the estate's value. But in the real world, that often means making judgment calls. Do we fix the roof leak or wait until sale? Do we pay for cleanup now or list it as is? Do we hire a landscaper or leave it dormant? No matter what you decide, the safest path is to document everything as you go forward. Here's what you should include. Receipts and vendor invoices. Keep every invoice, even small ones, from junk removal to pest control. If you're paying out of pocket, note the date, amount, and the reason clearly and share it with the estate attorney for future reimbursement. Before and after photo logs. Take timestamp photos when you first take over the property and after each major service. This creates a visual trail of responsible stewardship. Copies of insurance policies and utilities. If you've updated or transferred the insurance, save that paperwork. Same goes for switching to a vacant policy, turning off essential utilities, or any other holding decisions. Communications with attorneys and heirs. If you're discussing maintenance, access, or security with the attorney or beneficiaries, save these emails or keep a brief log. This shows that your actions weren't just responsible, they were also transparent. All this documentation protects you from second guessing, misunderstandings, and liability, especially in situations where the family is divided or where future disputes are likely. We coach our clients on exactly what to track and how to organize it, so that if a challenge ever comes up, you can say, here's what we did, and here's why it made sense for the estate. Question number 4 from fiduciaries. How do I build a real estate team to manage one of my clients' largest assets? Managing real estate as a fiduciary can feel overwhelming because it is. The legal responsibility is on your shoulders. The family pressure is real, and the property itself needs care, protection, and a strategy. But here's the good news. You're not supposed to do this alone. This work is too complex, too technical, and frankly, too important to handle without the right team in place. That's why we recommend building a team that includes the following: an attorney to keep your liability in check, a real estate broker experienced in fiduciary rent versus sale scenarios. Not just any agent, you need someone who understands probate, trust, conservatorships, and the ability to assess property values now and in the future for the best hold versus sell evaluations. You also need a financial advisor that can assist you with looking at alternative investment strategies for the real estate equity and further evaluate if selling or holding the real estate makes sense now and in the future. You also need an experienced insurance agent familiar with vacant and trust-held properties. This is because regular homeowners insurance often doesn't cover vacant homes or estate-held assets. This agent would also be a specialist that can help you avoid costly gaps in coverage. Lastly, you'll need a licensed property manager for medium and long-term hold scenarios to help you manage and maintain properties for productivity and income, while working to limit your liability with tenants and others. Note that property management and real estate sales are two totally different businesses. Property management is a low margin, high volume business, and real estate sales are a high touch and lower volume business to maintain that high touch for clients. Don't hire a property manager that wants to sell your real estate or a realtor that wants to property manage, as their loyalties may be conflicted by the desire to sell down the road. The bottom line, you don't need to be an expert in real estate, law, or property management. You just need the right team behind you, and we're here to be part of that team for your success. Managing estate property isn't just about holding the keys. It's about preserving the value, protecting the estate, and proving you've done your job well. If you're facing property decisions as a fiduciary, don't go it alone. My team and I have helped hundreds of fiduciaries evaluate everything from tenant-occupied homes to vacant estates with major repairs needed for sale or hold. For help building your plan, call us today or visit probateagent.com.